Good morning. Welcome to ACS's annual Supreme Court preview. I'm Kara Stein, Vice President of Policy and Programs at ACS, which most of you likely know is a national network of lawyers, law students, judges, and policymakers who believe that the law should be a force to improve people's lives. So here we are again. After a Supreme Court term that many felt was lackluster, despite the much-delayed addition of a ninth justice to the bench, we are looking at an upcoming term that promises the high stakes we had grown accustomed to in recent years. You need only look at 2 weeks of oral arguments to see what I mean. During just those first 5 days, the court will consider the constitutionality of the president's travel ban, the legitimacy of Wisconsin's redistricting scheme, and whether American workers can be forced to arbitrate their disputes with their employers as opposed to have a day in court. Some might say the stakes are perhaps too high. To lead us through the discussion today with our distinguished panel, we have the privilege of welcoming a newcomer to this annual event, Stephen Schwinn. Steve is a professor of law at the John Marshall Law School in Chicago and is co-founder and co-editor of the Constitutional Law Prof blog, which I commend to you if, like me, you're a con law junkie. Steve regularly writes for the ABA Preview of United States Supreme Court cases, and he directs the ABA Media Alerts project for the Seventh Circuit. But perhaps, most importantly, he serves on the board of advisors to the Chicago Lawyer Chapter of the American Constitution Society. I've had the pleasure of working with Steve recently on what is our soon-to-be-released first ever ACS Supreme Court Review Journal, which is going to be forthcoming in October, and there were flyers out there if you want some more information. But now, without further ado, please join me in welcoming Steve Schwinn.
Thank you, Kara. And on behalf of myself and the panel, I'd like to thank Kara and Caroline Fredrickson and the whole team at the American Constitution Society. And we'd really like to thank you all for attending. What a fantastic turnout today. I'm really excited about this. And what an important time to be talking about these issues. It seems like every time I open the paper, there's a new constitutional issue coming up. It's a time that we really need to be engaged in these things. And so I'm pleased that you're part of this conversation today. And I'm really looking forward to hearing from our very distinguished panel. My job as moderator is basically to introduce the panelists and quickly get out of the way. And so I think I'm going to do that. What I'd like to do is give just a very short introduction for each of our panelists going to my left. Their full biographies are in your materials, so you can take a look, and then we'll get on with the program. So immediately to my left, Claire Prestel, who is Associate General Counsel at the Service Employees International Union, where she focuses on SEIU's litigation docket. She previously practiced at James & Hoffman, Public Justice, and Althusser-Burson in San Francisco. She's authored and co-authored amicus and merits briefs in Supreme Court cases on a full range of different topics. So we look forward to hearing from Claire today. To Claire's left, Anil Kalin. Anil is an associate professor of law at Drexel University and currently visiting associate professor of law at Washington University in St. Louis. He is very involved in the New York City Bar Association and the Association of American Law Schools. He focuses on immigration law, criminal law, United States and comparative constitutional law, privacy and surveillance, and human rights issues. And that was quite a mouthful. To Anil's left, Marty Lederman, who's Associate Professor of Law at Georgetown University Law Center. Marty served as Deputy Assistant Attorney General in the Department of Justice's Office of Legal Counsel from 2009 to 2010, and as Attorney Advisor in OLC from 1994 to 2002. He is an active contributor to media and blogs, a regular contributor to Balkanization, SCOTUS blog, Opinio Juris, and Slate, among his other very many activities. We're pleased to have Marty join us on the panel today. And to Marty's left, Dale Ho. Dale Ho is the director of the ACLU's Voting Rights Project and supervises the ACLU's voting rights litigation and advocacy work nationwide. He's litigated a number of cases under the Federal Voting Rights Act and the National Voter Registration Act, and he's an adjunct professor of law at NYU. And then last, and certainly not least, to Dale's left is Aaron Murphy. Erin is a partner in the Washington, D.C. office of Kirkland & Ellis. Her practice focuses on Supreme Court, appellate, and constitutional litigation. She's argued 3 cases before the United States Supreme Court, and she has more awards and recognitions than I think we have time for today. But this is our wonderful panel. Would you please join me in welcoming them? Thank you very much. With that, I'm going to say just a brief word about ground rules and then turn it over to Anil to talk about one of the cases that we're all waiting to hear about, the travel ban. So each of our speakers we've asked to speak for about 10 minutes. We've asked that they consider intervening with each other as we go, and that will leave us about 30 minutes at the end for questions and answers from the audience. So with that, I'll turn it over to Anil.
Great, thank you so much, and thanks to ACS for including me and inviting me to participate in this event. It's interesting to be discussing immigration in the context of the Supreme Court because the Supreme Court doesn't typically grant certiorari for a lot of immigration cases. They're typically 1 or 2, in the last 10 years, maybe 1 or 2, maybe 3, and not necessarily raising big constitutional questions. This year, the court has already agreed to hear 3 cases. Of course, the one that was referred to arising from the Muslim entry ban, in 2 consolidated cases, but also 2 cases that were heard last year and then scheduled for re-argument in this term with the 9th Justice having been appointed, Jennings versus Rodriguez and Sessions versus DiMaia. And so I'm going to mostly talk about the entry ban case, although I'll say a little bit about Rodriguez as well and DiMaia if there's time, especially insofar as they might raise similar issues that are related. By way of context, for people who may be less familiar with how constitutional issues arise in the immigration context, there's 2, you could oversimplify and say there are 2 lines of cases that are somewhat in tension with each other. On the one hand, going back to cases dating to the 19th century, the court has held that the political branches have quite a bit of, are afforded quite a bit of deference in the area, in their substantive decisions on immigration with very limited judicial review. This line of cases dates back to the late 19th century, the era of Chinese exclusion, and has never really been revisited directly. Predates the constitutional rights revolution. But on the other hand, in more recent cases, even back then, procedural due process was still respected in limited extent and in a more robust sense since then. But the court has more recently indicated that there are limits in cases like Zedvitas versus Davis, or in a different way, INS versus Chadha, that just because the case may involve, the issue may involve immigration, that doesn't mean that what the political branches do is entirely immune from constitutional review. Those have never been fully reconciled. They're in somewhat tension with each other, and often what the court has done is to use the canon of constitutional avoidance when possible, or look to procedural surrogates for substantive adjudication, to use to draw from the work of Hiroshi Motomura, and those kinds of approaches may be at issue in the cases that arise this term. The entry ban case, I'm sure most of you are familiar with a lot of this because it's in the news, so I won't belabor a lot of details. Of course, there was the first executive order that was issued soon after the new administration came to office that was widely understood to be effectuating a campaign promise that initially was formulated as a total and complete shutdown of Muslims entering the United States. That then evolved over time in how it was framed, and that first executive order was, of course, enjoined, and then rather than litigate it, the White House issued a new executive order in March, even as it maintained that that executive order was simply a watered-down version of the first one in response to the Ninth Circuit's decision, the various injunctions, and ultimately the Ninth Circuit's decision affirming the Washington injunction, but really seeking to accomplish the same goals. So the cases that are before the Supreme Court, one from the District of Maryland, affirmed by the Fourth Circuit, one from the District of Hawaii, affirmed by the Ninth Circuit, are concerned this second executive order, which has a number of different provisions. that are at issue. The first one involves the suspension of entry of nationals from 6 Muslim-majority countries for a period of 90 days in order for various agencies to conduct a review to identify what additional vetting was necessary. And the order included a number of exemptions that were not in the first executive order, for example, for lawful permanent residents, dual citizens of other countries, and then also authorized a waiver that was not available in the first executive order for officials to exercise case-by-case discretion. These review provisions provided that an internal review was to be conducted within 20 days of the effective date of the order, and also directed upon submission of that report that there would be, that the Secretary of State would then begin to request other governments to provide additional information about what information the United States wanted from other countries about nationals seeking to be admitted to the United States. And that was supposed to happen within 50 days. So subsequently, over the summer, the Supreme Court modified its second executive order to change the effective date such that the effective date of each provision would be when any injunctions were lifted as to those particular provisions. So the Ninth Circuit lifted the injunction as to the internal review proceedings on June 12th. So now all of those internal provisions will by now have run, the review provisions in terms of the time periods that are prescribed in the executive order. Section 6 of the executive order suspended the U.S. refugee admissions program for 120 days and then also reduced the number of refugees that were authorized to be admitted for this fiscal year from 110,000 to 50,000, also removed an express religious preference in the first executive order. So you have these two cases working up. In the Fourth Circuit, the issue was resolved on constitutional grounds. The Fourth Circuit concluded in a divided en banc opinion that the district court enjoined the Section 2C of the entry ban provision, didn't address the refugee provisions, but did so when the Fourth Circuit affirmed, it affirmed on a constitutional ground under the Establishment Clause. The dissenting opinions in that case essentially took issue with the majority looking beyond the face of the executive order itself to reach its conclusion that religious animus was motivating the order, although the court did also look to some evidence that was on the face of the order itself, with one dissenting judge raising a concern that Donald Trump might in his words, never be able to free himself from the stigma of bias that the district court has enshrined with its preliminary fact-finding. In the Hawaii order, by contrast, the district court enjoined both the entry ban as well as the refugee, curtailing of the refugee admissions program. And then when the Ninth Circuit affirmed that, the three-judge panel rested its decision on two separate statutory grounds, that it wasn't an exercise of the delegated authority from Congress and that it may have run afoul of an anti-discrimination provision in the immigration law. So the Supreme Court granted certiorari in both of these cases over the summer and partially stayed the injunction, which allows the entry ban to go into effect as to individuals who cannot credibly claim bona fide relationships to persons or entities in the United States. And there's been a decent amount of litigation about the scope of that, what the Supreme Court said, which we can talk about in the Q&A if folks are interested in. There's a good chance that by the time this case is argued next month, it will be regarded as moot. And I should note that Professor Lederman has written quite a bit about this issue, I think mostly on just security, and I certainly would commend those pieces to you. Because presumably the period will have ended now that the stays have been lifted, and by the time the oral argument comes around, all of the time limits in the executive order, even as modified, will now in fact have run. It's also by then, presumably then a new executive order will be issued, and the focal point of this issue will turn to that. Should it reach the merits, it's not by any means a given that it will ultimately be decided on constitutional grounds because there are these statutory issues, and so it may well be that either by avoidance grounds or just straightforward statutory interpretation, the court doesn't reach these constitutional questions. With just a couple of minutes left, let me just quickly say something about Jennings, because I think, especially if the court doesn't reach these issues in this litigation and does, in fact, conclude that the case is moot, some of the issues in Jennings might become relevant. So Jennings involves presents the court with a challenge of how to navigate between two decisions that are in tension with each other. Zedvitas versus Davis from 2001 and Demore versus Kim from 2003. Zedvitas held that indefinite, potentially permanent detention of an individual who faced no reasonably foreseeable likelihood of being removed raised serious constitutional questions under the Due Process Clause. And in light of those constitutional concerns, the court interpreted those provisions to not authorize indefinite detention, but rather to require periodic review of the need for detention. On the other hand, Demore versus Kim decided a couple years later, sustained against constitutional challenge a statutory provision that categorically mandates detention for individuals based solely on their being deportable due to prior criminal convictions, as opposed to having an individualized determination of whether they're a flight risk or a danger to public safety. And unlike the individuals in Zedvitas, those are individuals who don't have final orders of removal. And so again, in Rodriguez, it may be that this case will be decided on statutory grounds if the court wishes to invalidate this policy. That is how the Ninth Circuit did so. At oral argument last year, there was some discussion about how to apply the avoidance canon, and that is something, to the extent that there's a different approach taken in Rodriguez, then that could affect how the avoidance canon is applied in other contexts. There's also the issue involving the strength of the plenary power, and also in each set of issues, there's a concurring opinion in the past from Justice Kennedy that might bear upon how the court might act in this case. So I'll stop there. We can leave Sessions versus DeMaio, and we can talk about that in the Q&A if folks are interested.
All right, thank you very much, Mel. Next up, we'll hear from Clara Prestel about some arbitration cases and possibly about a case that may be on the court's docket dealing with labor issues.
Yes, so as mentioned, I work for the Service Employees Union, so I'm handling the cases about workers. These two cases are linked to each other because they're about employment. They're also, in my mind, connected because they have a real chance of being a 1-2 punch against workers' rights that we haven't seen the chance of since the 2013 term. And what I mean by that is in 2013, we had a case called Mulhall, which fortunately, in my view, cert was ultimately dismissed as improvidently granted. But that was an attack on private sector employees' ability to band together and organize. At the same time, that term was another case called Harris versus Quinn, which went after the ability of public employees, in particular home care workers who are paid with public monies to organize. And so in this term, we have sort of the same situation where you have the first set of cases I'm going to talk about. It's 3 consolidated cases. The lead one, I think, is called NLRB v. Murphy Oil. And that's an attack on private sector employees' ability to band together. And then the second case in which cert has not been granted and might not be granted is called Janus versus AFSCME. And that is an attempt to make every state in the country right to work for all public sector employees. So first, with respect to Murphy Oil, I think the relevant legal background that's helpful to understand the case is that the National Labor Relations Act and another statute that's less commonly talked about, but the Norris-LaGuardia Act, those 2 statutes from the early 20th century both sort of provide one core protection for workers. And the core protection in both statutes and the core right that they guarantee is the right of workers to band together and work together to defend their rights or advocate for themselves, whether it's in litigation, testifying before a legislature, more traditional things that you think of like strike. And both statutes protect both union members and also non-union members. So it doesn't matter if you're in a union, you just have this right. At the time that Congress enacted both of those statutes, it was very well aware of the possibility that employers might try to get workers to waive their rights. And that was forefront in Congress's mind because part of what motivated the statutes were these things called yellow dog contracts, which was a requirement that your employer would say, I'll hire you, but only if you sign here saying that you will never, ever, ever try to form a union. And so Congress, that was one of the practices that Congress wanted to get rid of when it passed the NLRA and the NLGA. The other thing that's interesting about those cases, those statutes, is that at the time, they were thought of as the more sort of free market solution to the problem of income inequality and workers' rights, because the point of both statutes is to facilitate a private ordering of labor relations, facilitate private negotiation, as opposed to imposing set requirements like a minimum wage or leave, stuff like that. The idea was that if you just give workers the ability to band together, they can negotiate to a fair deal themselves, and you don't need as much of the top-down regulation. So both statutes prohibit employers from requiring employees to waive their rights. The NLGA strips courts of jurisdiction to enforce such waivers. The NLRA goes a step further and makes an employer's requiring of such a waiver an unfair labor practice. The Norris-LaGuardia Act also includes a provision that refers particularly to workers' rights to support each other in litigation. So the issue in these cases called Murphy Oil and the related cases is whether employers can require their employees to waive their right to participate in collective action, to band together with other workers, if they embed that collective action ban in an arbitration agreement. And just to be clear, because sometimes this is not clear, the provisions that are at issue in these cases, they ban not only class actions, not only collective actions, they even ban things like joinder or co-plaintiffs. Simply put, the question is whether or not we're going to return to an era of yellow dog contracts, just in sort of a slightly different form. And the parties in the cases basically fight over two different things. One is whether the various relevant statutes can be harmonized, so the NLRA, the NLGA, and also the Federal Arbitration Act. And if so, great, stop there. And if not, which statutes should prevail? So on the first point, both sides say that all the statutes can be harmonized. Not surprisingly, they would harmonize them differently. There are a lot of arguments for why the FAA can be harmonized with the NLRA and the NLGA in a way that protects workers' rights. One of those, I won't go through all of them, but some of the most straightforward are that the FAA itself includes a savings clause that says that the point of this statute is just to make arbitration agreements as enforceable as any other contract, but not more so. And so any defense you would have against a regular contract, you should also be able to have against an arbitration agreement. And here, this kind of collective action ban would be invalid and illegal if it were in any other kind of agreement. So you would think that that savings clause would apply. The other side's strongest argument, I guess I would say, is that in some cases the court has talked about requiring something called a clear congressional command before it will conclude that an employee has a right to a judicial forum as opposed to going to arbitration. The problem with those cases is that, or the reason they're arguably not applicable, is in the past when the court has applied the clear congressional command standard, it has never done it in a way that strips people of substantive rights. And here, the right to engage in collective action is the core substantive protection of both of our federal labor laws. Also, usually the court applies that clear congressional command standard when an employee is saying that they have an absolute right to go to court. They can't be sent to arbitration. And here, that's not what we're talking about. The NLRB actually said, you can force your employees to go to arbitration. What we're talking about is you just have to allow them to do it as a group, whether in court or in arbitration. So this is really about a collective action ban that has just been embedded in an arbitration clause, not sort of the issue of arbitration itself. So the second case I was going to talk about, Janus versus AFSCME. Again, this is at this stage just a cert petition. And before I sort of would go into the merits, I would just say that, I think the conventional wisdom would be, or has been, that the court is likely to grant cert because it took a case called Friedrichs last term. Having read the papers, I will say that I'm a little bit more optimistic that the court will deny cert or there are legitimate reasons to deny cert. For one thing, there's a sort of basic jurisdictional problem in the case and a question about whether the courts ever had jurisdiction over this case. And I won't go into the details, but given that, if you're going to, what the National Right to Work Foundation is asking in these cases is to overturn, a 60-year-old precedent. And I think if the court is inclined to do that, it might want to do it in a case where it doesn't have this sort of outstanding question with respect to its jurisdiction. There are also pleading problems. The complaint, this has all gone up on a complaint, and it's just sort of very conclusory if you were actually to apply Iqbal seriously. But on the substance, basically the idea is that no employee in the United States, public or private, has to ever join a union if they don't want to, never has to pay to fund a union's political activities. If a majority of workers in a workplace decide to unionize, then that union becomes the exclusive representative. And what that means is that the employer has to bargain with it, and also the union takes on a duty, which is once you're chosen by the workers and become the exclusive representative as the union, you have a duty, a legally imposed duty, to represent both members of the union and non-members. It's called the duty of fair representation, and any union can be sued for violating it. So what has been worked out over time is a system where, because non-members of the union are entitled to union services, so for example, if they want to bring a grievance, they can be required to pay a small fee, which is called an agency fee or a fair share fee. They don't have to pay for any of the political expenses of the union. They're just required to pay a small fee to cover the cost of the services that they are actually receiving. And so what this case says, or argues, Right to Work argues, is that as a matter of the First Amendment, it is unconstitutional to require non-members to pay even for the services that they provide. So in other words, as a matter of the First Amendment, non-union members should have the right to receive union services for free. And, I think, and it's time for me to stop, but I think you can imagine sort of the consequences of that kind of system. You end up with a basic collective action problem that any economist could have explained to you 100 years ago, which is you get all the services for free, it gets a lot harder to convince anyone to become a member, which is why we don't have that system in the first place. But anyway, I'll stop there.
Excellent. Thank you very much, Claire. Now we're going to hear from Dale about a political gerrymandering case and possibly about another voting case.
Thanks. I'm going to talk briefly about two cases in the court, Gill versus Whitford and Husted versus A. Philip Randolph Institute. In introducing Gill versus Whitford, I'm going to steal shamelessly from Pam Carlin, who has described this case as being one about a constant feature of our politics, one that starts with a discussion of lofty ideas, moves to a situation where a few people retire into a room, and there, in Justice Souter's words, there's a pull, haul, and trade of interests, and the process ends in someone getting screwed. I'm talking not about the management of Ted Cruz's Twitter account, but about redistricting, and specifically partisan gerrymandering. Gill versus Whitford is the first partisan gerrymandering case to be heard in the Supreme Court in over a decade. The last one ended inconclusively, you could say without satisfaction for anyone, in which 4 justices held that partisan gerrymandering claims are non-justiciable. 4 would have found the redistricting plan at issue in that case unconstitutional. And Justice Kennedy, sort of in the middle, agreed that the plan was not unconstitutional, but did not want to go so far as to say that no partisan gerrymandering claims could ever be justiciable, just that the court had yet to arrive at a manageable standard. So this case tries to take up that challenge and articulate a manageable standard for assessing when partisanship in the redistricting process goes beyond sort of the ordinary injection of politics into redistricting and becomes so excessive as to become unconstitutional. One of the innovations that the plaintiffs have introduced to this area of law that's much discussed in some of the coverage of the case is something called the efficiency gap, developed by one of the lawyers in the case, Professor Nick Stephanopoulos of the University of Chicago. The efficiency gap attempts to measure each party's wasted votes at the statewide level. That is, the number of votes cast for losing candidates and the number of votes cast for a winning candidate beyond the level that that candidate needed to receive in order to actually win that seat. And then compares the number of wasted votes that each party receives on a statewide level and calculates a ratio, and purports to show that at a certain level, the ratio is so extreme that one party is effectively locked into power, entrenched for a decade, after which the cycle then perpetuates itself. In a 2-to-1 decision, the lower court, and this was a district court, a 3-judge district court rather than a court of appeals, because challenges to a statewide redistricting plan under the Constitution go to a special 3-judge court. The district court held in a 2-to-1 decision that the plan was unconstitutional. It discussed the efficiency gap but did not rest exclusively on it. It found a range of evidence that the Republicans in Wisconsin had entrenched themselves effectively for a decade. I thought one of the most interesting facts that the court identified was the share of the share that each party got in 2012 and 2014 in terms of statewide vote and the share of seats that each party got. So in 2012, Republican candidates for state assembly got 48% of the votes statewide. That's a minority. They got about 60% of the seats, a supermajority. But in 2014, Republican candidates for state assembly got about 52%, so they did much better, right? They got a majority. And again got about 60% of the seats, right? So what's interesting, I think, is not so much the disproportionality, but the fact that the GOP candidate vote share really made no difference in terms of the seat share. Either way, whether they were getting a minority or a majority of the votes statewide, they were effectively locked into a supermajority of the seats. Now, Wisconsin makes a variety of arguments as to why this fact or the efficiency gap do not demonstrate entrenchment. There are a variety of issues in the case, including issues related to standing. I just want to focus on one issue, and that's this question of whether or not the disproportionality that we see sometimes between a statewide vote for candidates of one party and the translation of that vote into seats is due to gerrymandering or to political geography. This phenomenon is sometimes referred to as the big sort, right, in which liberal voters tend to be clustered in densely populated urban areas that are very, very liberal, in which districts are maybe 80% Democratic, or the vote share sometimes goes 80% for Democratic candidates, whereas conservatives tend to be more spread out in rural areas that are conservative, but perhaps less so. And if you think about, say, maps of which presidential candidate won which counties, right? Sometimes you see these maps after an election, and you tend to see this sort of sea of red surrounding little islands of blue in urban areas. I think that kind of gives you an idea of what this phenomenon looks like. And the result is that Democrats naturally have more wasted votes in any system of representation that depends upon geographically compact single-member districts. The question that I think that's posed here is how much of that bias can be attributed to natural sorting and political geography, and how much of it can be attributed to gerrymandering, and is there a way to develop a judicially manageable standard that enables a fact finder to determine the difference. There are a lot of amicus briefs in this case. I think there's one for every man, woman, and child in the state of Wisconsin. I'll just talk about the ACLU's brief very briefly.
What percentage of them are wasted?
Not ours.
There should be a study in a paper.
There will be, I'm sure.
So the ACLU's brief arises from First Amendment principles, and two principles in particular. First, that there's a principle of government neutrality in the public sphere drawn from freedom of speech cases, and second, that voters have a right to associate freely with their candidates and parties of choice, a freedom of association that is impermissibly burdened when one party has so entrenched itself that shifting voter preferences have no meaningful effect on the distribution of political power. Some parting thoughts about the case. It has, I think, the potential to be the most significant voting rights and redistricting case since Reynolds versus Sims established the principle of one person, one vote, a case that Chief Justice Warren himself described as the most significant case that he ever authored. If you just look around the country, there are reasons to think that we have something of a crisis of democratic accountability right now. You look at a state like Maryland, where Democrats statewide get about 60% of the votes and yet control 7 out of 8 congressional seats and a huge supermajority in the state legislature. You look at a number of states that are about 50-50 in terms of the statewide vote that candidates from the parties get: Michigan, Pennsylvania, Ohio, Virginia, North Carolina, but where the GOP has a supermajority both in terms of the congressional delegation and the state legislatures. I think the best political science on this suggests that the massive disproportionality that we see in a lot of states and the entrenchment of one particular party is not fully attributable to political geography. There are, I think, reasonable estimates that as much as the 15 seats of the Republican advantage in Congress right now can be attributed to gerrymandering. So if the plaintiffs succeed in this case, it has the chance to have immediate consequences for redistricting around the country and the distribution of political power, and introduce an entirely new limiting principle in redistricting processes going forward decennially. Briefly, I'll mention one other case, Houston versus A. Philip Randolph Institute. This is an ACLU case that we are litigating with the organization Demos, a challenge to an Ohio voter purge program in which if you live in Ohio and you are registered to vote and you do not vote in a 2-year period, that is for like essentially half of the electorate not voting in a midterm election, you're marked for possible removal based on the assumption that you have moved to another jurisdiction and are no longer eligible to vote in that jurisdiction. You're sent a notice, and if you do not return that notice and do not vote during the next 2 federal election cycles, you're removed from the rolls. The Sixth Circuit, in a 2-to-1 decision, found that this violates the National Voter Registration Act. The effect of that ruling was that 7,500 voters who cast ballots in the 2016 election, people who had not moved and were indisputably eligible to vote, the state of Ohio concedes this, cast ballots. They had been purged under this process, and had the Sixth Circuit not ruled the way that it did, these voters would have been disenfranchised and their ballots would have gone uncounted. The dispute in this case centers on a provision of the NVRA, the Motor Voter Law, which provides that any program that results in the removal of voters by reason of their failure to vote is prohibited. Congress enacted that prohibition specifically because they were concerned about programs that kicked people off the rolls for inactivity. There were concerns that, in particular, these kinds of programs were essentially a re-registration requirement that disproportionately affected minority communities where turnout tends to be lower. And in fact, a Reuters analysis in 2016 found that this purge program disproportionately affected people living in predominantly African-American communities. The case will be argued in November. Thank you.
Excellent. Thank you, Dale, for those terrific summaries. We're going to next hear from Aaron, who will talk about a really important Fourth Amendment case coming up, and if time permits, about an alien tort statute case.
And I am going to talk about Carpenter, but just to keep things interesting and to make sure nobody gets the wrong impression from the fact that I'm sitting to the far left of all my co-panelists today, I just want to say a couple of quick words about the Wisconsin case, we're pretty heavily involved in the case. We represent the legislature there as amici. And it's such an interesting case, so I just wanted to share a few views about it. There's a lot of discussion in the case about how we can identify the partisan impact and whether we can find this narrow and precise test that everyone's looking for to figure out how much partisan is too much partisan in gerrymandering. But it seems to me that the fundamental problem is there's a lot less discussion from the plaintiffs and their side of the case of how we're going to map any of that onto a constitutional violation. And in thinking about that, I think you have to think about how this is very different from the context of racial gerrymandering. The court has said in that context, the injury is the idea that it's an equal protection violation to be sorting people on the basis of race. That theory doesn't work when you try to apply it to sorting people on the basis of partisan affiliation. One, because it's never been treated as a suspect classification in the same way, and two, because the reason it's not treated as the same kind of suspect classification as race is because partisan affiliation is not an immutable characteristic. You can change your partisan affiliation, and the way you vote in one election may not even dictate how you're voting in other pieces of the same election, let alone in future elections. So just because I want, the Republican in my particular district doesn't even necessarily mean I want the Republican candidate for governor or whatever else it may be statewide. And to me, the real question in this case is, does any of this map on to an actual constitutional theory of injury in the notion that, I have an interest not only in being put in a district where my vote counts in a certain way for purposes of who I'm voting for, but also in such a manner that the districts are arranged so that, there's a proportional representation statewide that reflects the way that I voted in an individual election. I think it's particularly fascinating for all of this to arise in Wisconsin, which is really kind of your quintessential purple state, where you have voters that really are voters who consider themselves independent, who may in the same election vote for one Republican and one Democrat, who may want divided government among, between the House and the Senate, between the legislature and the executive. So the notion that people have a protected interest in ensuring that however they vote in particular elections sort of is reflected all throughout the state, not only to me is constitutionally problematic, but also just isn't really right and may be attributing to people things that aren't what they want. Now, of course, there are plenty of people who vote in a particular way all the time, and that they have a practical interest in that. But I think that's the real issue in this case, and it'll be very, very interesting to hear argument in this case and have that fundamental theoretical debate, because that's the debate that's been going on in partisan gerrymandering cases for quite some time, and is really the debate at the heart of kind of the standing and justiciability issues in the case. So with that said, I will talk about what I'm supposed to be talking about, which is the Carpenter case, which is, to me, another really, really interesting case, really interesting set of criminal issues, the Fourth Amendment case. This is a case about so-called cell site data, cell site location information, which is the data that your cell phone company keeps in. They keep records of every time your cell phone is connecting to a tower to ensure cellular service. They have a record of what tower you're connected to. So if you think about it, if somebody gets a hold of those records, they can learn a heck of a lot of information about you. It's sort of a little more rudimentary version of GPS, because it's not an exact location of where you are, probably a 1 to 2 mile radius. But those records can basically show kind of where you are 24 hours a day, since most of us have our cell phones on us most of the time. And that's exactly what what the records were used for in this criminal case. Mr. Carpenter was charged with Hobbs Act violations for a string of robberies, and the government obtained these records from his cell phone company, and introduced them at trial to demonstrate that he was in the vicinity of each of the relevant robberies, and it obtained that information without a warrant. It had a court order. I'll talk a little bit about that in a moment, but it obtained it without a warrant. And so Mr. Carpenter argued that this was a violation of his Fourth Amendment rights. It was an unreasonable search. The Sixth Circuit disagreed, and relying on this doctrine known as the third-party doctrine, concluded that there wasn't a search at all because this information, he knowingly allowed his cell phone provider to have this data, and it's just information that a third party is keeping in records, and therefore there's not really, he doesn't own this information and have a privacy interest in it such that the cell phone company can't release it without running without engaging in a search. And the Sixth Circuit was not alone in reaching that conclusion. Most of the courts that have confronted this issue, the lower courts had concluded that obtaining this kind of information without a warrant doesn't violate the Fourth Amendment. There have been plenty of dissenting views along the way, and this has been a really hotly debated issue in the lower courts. But as this petition came to the Supreme Court, there wasn't really a circuit split. But the court nonetheless decided to take the case after about 4 months of relisting it. So all of that suggests that the court is, pretty concerned about this issue because it doesn't usually reach out to take an issue when the lower courts aren't actually strictly divided on it. So I think, from that alone, that there's some concern probably if you're in the government's shoes. I think if you take this case also in the trajectory of recent cases from the court in which the justices have shown particular concern about how the Fourth Amendment is going to apply to technology in the modern age, that also would suggest that the government's got some problems here. Probably, to me, the most important of those cases to look at in terms of putting all this in context is the Jones case a few years back involving GPS search, and there the court unanimously concluded that attaching a GPS to somebody's car was a search. Now, what's interesting about that case is while the court unanimously reached that conclusion, there were very different views about how to get there. You had a 5-justice majority concluding that that was a search because it was a physical trespass to attach the GPS device to the car, and therefore that you had an expectation of privacy based on trespass law. You had a different 4 justices saying, no, we would get there by saying that people have a reasonable expectation of privacy in the information that is obtained from a GPS device, and that this is just totally different from anything historically that you would have thought of as the kind of information the government could obtain without a warrant. And then you had a concurrence from Justice Sotomayor, who was in the 5-justice majority, saying, look, I do think that we can resolve this case on trespass grounds, but I'm kind of with the 4 concurring justices in saying that I also think that there's a reasonable expectation of privacy problem here. And in particular, she noted that she thought the court might need to re-examine this third-party doctrine that's underlying these cell site cases, and that we need to rethink the idea that in the modern age, every time we sort of allow somebody, that our relationships with a cell phone provider or some sort of other technology provider to give them access to information, to give them access to our email, for instance, that we've somehow implicitly consented to that information being equally available to the government without a warrant. So you have a lot of indications here that make this look like a tough case for the government. But I do think it's a little more complicated than that because there are, there's some difficulties here, and I think that's kind of evident in the petitioner's brief, which is written in a pretty narrow way. They have explicitly declined to ask the court to overrule the third-party doctrine, which I think a lot of people would like the court to do, but they made a judgment call that probably makes a lot of sense to try and tell the court, look, there's nothing wrong with this doctrine in other contexts. It just is something that shouldn't apply here because there's a stronger interest, a privacy interest at stake when it comes to revealing my location 100% of the time. I'm not sure that argument to me is completely practically satisfying. The court has allowed the third-party doctrine to be used to obtain, for instance, basically all financial records, and in this day and age when very few of us use cash all the time, I think, you can learn a heck of a lot about me from obtaining my financial records on a daily basis, not only where I am, but exactly what I'm doing wherever I am. So, that's not to say I don't think the court might latch on to that as an easy way to distinguish those cases, but it's not simple. And the other thing that makes this case, the last thing I'll say, really interesting is the information here was obtained pursuant to a federal statute that, while it doesn't require a warrant, did impose constraints on what had to be shown to a judge to get an order from the judge allowing the government to obtain these records. So the government has an argument that, even if this is a search, even if there's a Fourth Amendment interest here, there's a statute, and that statute makes this a reasonable search. And notably, the petitioners here, their first response to that argument is to say, maybe you should punt on that, Supreme Court, and kick it back to the Sixth Circuit and let them address in the first instance whether, even if this was a search, it was a reasonable search. So I think there's some complications in here that will make this an interesting case, even though I think a lot of people have a pretty strong instinct that the court is going to have a pretty strong instinct that it's very troubled by the idea that the government can obtain this kind of information without a warrant.
Excellent. Thank you very much, Aaron. I hope that we can explore this difference between political gerrymandering on the one hand and racial gerrymandering on the other, maybe during the Q&A period. Thank you very much. And then last but certainly not least, we're going to hear from Marty Lederman, who will talk about the Masterpiece Cakeshop case.
Thanks very much. Before I do, I want to pick up on something Aaron just talked about in Carpenter and also the travel ban case, just to give you a sense that the resolution of both of those cases might be different from what you're expecting. And Aaron suggested, I think at the end of her remarks, a very possible splitting the baby in half sort of answer from the court, right? The principal question presented to the court is whether this collection of the cell site database location information, at least in bulk, is a search subject to some Fourth Amendment scrutiny. I do think that there's at least 5 justices, maybe more, maybe even 9 justices, who might decide that the answer to that question ought to be yes, that governments ought to be subject to some limitations in terms of how they can collect these databases of information that reveal so much about ourselves. However, there may also be a majority of justices within that group who believe that the standards that Congress enacted in the Stored Communications Act is sufficient because, in particular, it's a little bit more robust even than what the government would have to show in a grand jury subpoena for this very same information. And the grand jury subpoena issue, I think, is sort of the gorilla in the middle of the room that no one's talking much about in this case. And the court's doctrine on that is old and hasn't been rethought in a long time, but it's very, very easy to use grand jury subpoenas to get virtually any sort of information from third-party providers, from third parties of all sorts. And there's some justices who might think that at least as long as that's true, the standard that Congress set up here suffices. So this satisfies the Fourth Amendment, even though it's subject to Fourth Amendment constraints. On the travel ban, as Anil suggested, I think it's very unlikely the court will reach the constitutional question. If it reaches the merits, I think it's likely to resolve the case on statutory grounds. But besides that, he's right to suggest, I think, that it is likely that President Trump will issue either an amendment or an extension of the executive order now that the whole review process is virtually completed, in which they will either impose different constraints from maybe a different set of countries altogether now that the review is virtually completed, or say that they are almost done with that review and so they need an extra 30 or 90 days or however many it is of the travel ban to stay in place. But they've obtained a lot of information from all the nations of the world in this review process, and we don't know what that is yet. And so I think, if not mootness, a very likely result either before or after oral argument is that the court remands the case for reconsideration or for refiling based on the new facts and circumstances after the president changes the executive order. I'll probably be proved wrong in both of those cases, but just so you're not surprised if either of those happens. Masterpiece, I'm going to assume that most of the people in this room know about Masterpiece. It's one of the sort of sexier cases on the docket this term, involving the law of cake, right? And whether cake speaks. So I'm just, rather than going over the details of the lower court decision or many of the facts in the case, which I assume you know or you could know if you listen or view any of the other Supreme Court review panels that are all over the internet right now, I'm going to give a little bit of historical background in two respects. So one is looking long-term back. It has long been the case that the common law has required some sorts of businesses and vendors to make their services available to everyone, innkeepers and common carriers in particular. And more recently, in recent decades, or the last 100 years or so, that has been complemented by a number of state statutes requiring they're all different in some respects, requiring anti-discrimination norms with respect to other sorts of vendors on various grounds, the most common of which are race and sex and religion, of course. But Colorado's statute, and then famously Title II of the '64 Civil Rights Act, provides that in places of public accommodation, which don't cover these sorts of businesses, but do cover hotels, restaurants, and the like, entertainment facilities, race and religion cannot be used as a ground for discriminating against customers. Colorado has gone a little bit further in two respects. It applies its anti-discrimination law to virtually all businesses, and it also extends it to discrimination on the basis of sexual orientation. By my count, approximately 21 states in the district do so. So Colorado does not allow any of its commercial vendors, I believe, to discriminate against their customers on the basis of sexual orientation. Now, the historical context is, over the years, these anti-discrimination norms and these common law rules have constantly been subjected to constitutional challenge under property rights, contract rights, freedom of religion, freedom of speech, freedom of association, and the like. And they have very, very rarely gotten any traction at all from the Supreme Court, or for that matter, from many of the other courts over the years, particularly when it comes to race and sex discrimination. These sorts of claims were uniformly rejected in many cases, including Heart of Atlanta Motel, Piggy Park, Bob Jones University, Runyon versus McCrary, a whole line of cases. And this is just one in that series, and you might think, well, it should get the back of the hand. These constitutional defenses, these constitutional claims for exemption from the anti-discrimination law might be treated the same way, but that brings me to my second sort of historical, contextual point. When the court 2 terms ago decided that there was a constitutional right to same-sex couples to be married, the court also, in the majority opinion by Justice Kennedy, went out of its way to emphasize that it did not view objection to same-sex marriage in the same way that it views racial discrimination, thinking that most people who object to same-sex marriage do so on long-standing religious grounds. I'll just quote from Justice Kennedy's majority opinion in Obergefell. This objection has long been held and continues to be held in good faith by reasonable and sincere people. Many deem same-sex marriage to be wrong, and they reach that conclusion based on decent and honorable religious or philosophical premises. That's nothing like anything that any justice would have said about race discrimination, or even opposite race, a mixed race marriage in Loving versus Virginia. So I think a majority of the justices probably think it's a very bad idea for states, at least in the short run until the nation becomes more reconciled to same-sex marriage across the nation. It's a bad idea to require commercial vendors or others to participate in same-sex marriage when they don't want to. The court thinks that their objections are worthy of more respect than race discrimination and sex discrimination objectors. And so if the court had their druthers and they were in state legislatures, I think they would build in exemptions into these statutes. They think, a majority of justices probably think it's a bad idea that Colorado did not do so here. But that's a far cry from saying that there's a constitutional right to exempt oneself from those state statutes. I think that there might be a majority of justices who want to find a constitutional claim, but it's going to be hard to do so. It's very hard when you start thinking about it to figure out what the doctrinal limits are that don't bleed over into sex and race discrimination, that don't undermine a whole series, decades worth of doctrines in this regard. Now, the defendant here, Jack Phillips and Masterpiece Cakeshop, has raised free speech and free exercise objections. I'm not going to talk here about free exercise unless someone's interested in it, because I think almost everyone agrees that's going to be a futile claim. The court's not going to overrule Smith, and even if it did, they would lose under Smith the way these sorts of claims lost unanimously in the pre-Smith era. So the principal claim is one of compelled speech. The bake shop is claiming that over their religious objections, they are being forced to say something with the cake. So what are I'm going to be generous to the petitioner's brief. As I see it, their strongest case for a limiting principle is that they should prevail when both of two criteria are present. Number one, the vendor in question, the commercial actor, is him or herself engaged in some sort of First Amendment activity, creative artistic activity, and custom-made wedding cakes are that kind of activity. I think they're right about that. I think the court will hold that there's at least some constitutional protection for that, but that doesn't mean you win the case. And that won't be enough. It won't be enough that they'll say that everyone engaged in any artistic or expressive activity is entitled to exemptions, because that would prove way too much as to architects, and you can imagine all the different cases. So the second criterion they suggest is that, and in addition, the product or service that they create through this artistic activity inherently conveys a message that they don't agree with. Not that anyone will necessarily think or misattribute the message to them, but that they don't want to have to say that message in the same way the Jehovah's Witness students didn't want to pledge fealty to the flag in the Barnett case, and the motorists in New Hampshire didn't want to attest to live free or die in Woolley versus Maynard. And that a wedding cake in particular, a custom-made wedding cake, they argue, inherently says, celebrate this couple. A statement that Jack Phillips not only doesn't believe, but thinks is morally objectionable and religiously incorrect. And I think that's where the heart of the case where the justices might get tangled up or try to figure out, does a wedding cake inherently say anything itself, or does it only really say celebrate this couple by virtue of what the couple does with the cake? I'll tell you, if your wedding's anything like mine, my wedding cake didn't say anything even implicitly except what the cake in Alice in Wonderland said, which was, eat me. I mean, some people may have wanted to celebrate us, but not because of the cake. So I think that's going to be the hardest part for the justices who want to recognize a constitutional exemption, to try to articulate why a wedding cake is inherently expressive, and in particular, why the cake standing alone, rather than the use made of the cake by certain couples, this isn't at the wedding, this is at a party for the wedding, is inherently expressive, and whether that's a possible limiting principle that might make this a narrow decision. I don't think the justices are inclined to issue a broad decision that would provide constitutional exemptions to all sorts of anti-discrimination laws. It's much harder to reach that result than you might think, but having said that, I think you ought not to be surprised if there is a majority of justices who figure out a way to get there in a very narrow opinion. There are, I think, about 50 amicus briefs on the side of Masterpiece Cakeshop in this case, which is probably exponentially greater than the number in support of constitutional exemptions in any of the historical cases. And it includes the United States of America, which has filed for the first time in its history. In virtually all these other cases, the United States has filed against exemptions, which you can imagine, because they have anti-discrimination laws, or not filed at all. This is, I think, the first time in history that the United States has filed in favor of a constitutional exemption. And the Solicitor General has tried very hard to craft a very narrow theory for an exemption, although I'm not sure I quite understand what the limiting principles are quite yet in their brief. And so I do think that the challenge for those who would recognize the exemption is to figure out those limiting principles, which is a little bit easier said than done, but these are very smart and very creative justices, and I don't put anything past them.
Excellent. Thank you so much, Marty, for walking us through that. We have about 30 minutes for questions and answers, and I certainly have a full list of questions here myself. I imagine the panelists have questions for each other, but I think we'd rather hear from you. So we have some roving microphones. If anybody has questions for any of the panelists or the panel entirely. Yes, maybe up here in front, please.
Hi, I'm from Aspen, Colorado. I'm aware of our Hate Crimes Act.
Have you ever gotten a cake from Masterpiece Cakeshop?
I'm a lesbian. I was arrested at my church. My case was docketed at the U.S. Supreme Court, a habeas corpus case. I'm alleging that the Hate Crimes Act, 18 U.S.C. 249, 245, and 241, may not be enforced by our courts in America, from Aspen, Colorado, to the Court of Appeals, to the Supreme Court of Colorado, Federal District Court, 10th Circuit, and now at the U.S. Supreme Court. My colleague on my right and I have discussed what is hate and how are we interpreting the Hate Crimes Act for violations. I don't see many cases where our rights as lesbians, I would also include that there could be a gender discrimination. So you're so wise, and we appreciate your long hours in law school. So any of you, I would address it to anyone who has a thought on, are we in America enforcing the hate crimes acts that have been on the books? And we know that in 1973, homosexuality was no longer deemed a mental illness, and yet the judge deemed me mentally ill. So there's a lot of questions that we're addressing.
So these issues will not arise in Masterpiece Cakeshop or in any of the other cases on the court's docket this term. All I can tell you from experience and knowledge that the Obama administration Civil Rights Division did enforce the Hate Crimes Act against sexual orientation-based violence quite frequently. I'd have no idea what the Trump administration, Department of Justice, is doing with such cases, but I'm afraid that's a little bit far afield from this term's cases in the court. Perhaps there will be issues in the future that are raised before the court.
Thank you. This question at the table in the middle.
We have two questions about the Muslim ban case. The first one is with this mootness issue and the possibility of the president issuing an additional executive order. I was wondering if you could speak to the possibility of the court reaching the merits under the doctrine of capable of repetition yet evading review. And then the second question I have is whether or not you think the Trump administration or the court rather will be willing to consider Trump statements on the campaign trail.
Sure. So on the second question, I mean, that has been a subject of debate between majority and dissenting opinions in the lower courts, and I don't have a good read. I mean, we don't have a good read yet as to how the justices would engage that. I mean, my own view is that motivation is relevant to the doctrinal claim, and therefore you look to evidence of motivation. It's not just statements on the campaign trail. There is some evidence of religious animus that the plaintiffs have pointed to on the face of the order itself. There have been statements ongoing during the term of the administration. So I imagine that will come up. It certainly has been debated among the different judges in the lower courts. On the first question, I suppose that's plausible. I'm sure that there are other panelists who may speak to that as well. One question may be whether, as a prudential matter, they choose to hear it. You know, there's that going on too. I mean, it's possible they could hear it and then choose not to, because especially in the immigration context, given what I was describing in the long historical arc of how these issues arise on immigration, in the tension between the plenary power and there is often the court over a long period of time has looked to ways to avoid engaging constitutional questions. So one option would be to reach the merits and address it on statutory grounds. Another would be to reach the merits and address it on procedural grounds. Another would be to not hear the case, especially if it seems like it might return to them in some other form.
I would just add, it's not incapable of review, right? So the new executive order could be challenged, and will have different terms and conditions and perhaps different countries than the current one does. So,
I mean, I just to add one other thought. I mean, I think a good deal will depend on what the United States is saying and whether they want the court. I mean, if they're taking the position of, we want you to deal with this stuff, like, I think the court will deal with it. And, you know, we don't quite know exactly, I think at this point, what their approach on all of that's going to be. So it'll
I
be.
just don't think they're in a very, if they don't say anything more about what the review has demonstrated, they're putting themselves in a bad posture before the court. Either the review has shown that there are risks to national security or it hasn't, and they can't really
Yeah,
hide the ball on that.
I don't know if their view is going to be kind of, we've got something new, so let's go
Right.
figure it out in some lower courts, or their view is going to be, these lower court decisions are so damaging that we need you to do this, say something now. You know, I think there's a lot that's still going to happen between now and
I
the
agree.
argument that will impact the way the court's thinking about kind of the mootness issues and how much it should say
Well,
here.
and to the extent that that involves new factual assertions, it may be that remanding is the better course. I mean, and this goes to the issues in Rodriguez as well. That when the Rodriguez involves prolonged detention of people who are being detained pre-final orders of removal, but for a particularly long period of time. When the court reviewed some of the related issues in Demore versus Kim, the information that was presented to the court and in the first instance in the Supreme Court that went to how long the detention of the people who were affected by that at that time was that the detention was relatively short. And it is, you know, the Solicitor General went to the court last year, or the year that cert was granted in Rodriguez, and said, well, actually those statistics were wrong, and they were never tested by adversarial process. So that's also, that's in the air right now. So I would think that that would be a good reason that if there are factual assertions being made to the Supreme Court in the first instance, the court might want to remand before taking it up initially.
Just continuing on this theme, if I can ask a question of Marty in particular, or anybody who wants to weigh in on this. Marty, you had mentioned the statutory component of this piece, and I wonder if you can just talk a little bit more about that, and in particular, the president's exercise of authority to halt immigration in the national interest and the evidence that goes to national interest, which was the basis of the Ninth Circuit ruling.
So the statutory argument, in brief, is the president purports to be acting here primarily, and I think importantly, upon a statute that was part of the McCarran-Walter Act, a McCarthy-era statute in 1952, which afforded executive branch officials in many different areas of immigration, on the face of it, very broad discretion to exclude people from the United States, to prevent passports from being given to certain people and the like. And the statute itself, Section 1182 sub F, by its terms, seems to give the president virtually unbounded discretion to exclude the entry of any persons or classes of persons based upon any finding that such entry is necessary to advance a national interest. One question is that really as broad a delegation as the president is claiming it is? And the Hawaii plaintiffs in particular, the Hogan brief that was just filed this week, makes a pretty compelling case that, like the passport case, Kent versus Dulles, that the court decided in the 50s, this should be viewed against the backdrop of practices that preceded this 1952 statute and should be limited to certain sorts of claims by the president. And then there's a bunch of statutes enacted after 1952 in which Congress has seemed to demonstrate a distaste for, at a minimum, a distaste for national origin-based proxies for exclusions, right? For using national origin as a broad proxy rather than diving down more particularly into whether a particular person or group of persons is dangerous or is otherwise a problem if they are to enter into the United States. I think the Establishment Clause questions are very complicated and difficult and novel. I don't think the court will have much stomach to resolve them one way or the other. I think the possibility of saying that 1182 doesn't give the president the authority to do what he did here will be tempting to at least certain justices. I have no idea whether it will be a majority. In part because I think, and I doubt this would be in the court's opinion, I think at least some justices must feel, as I do, that although President Trump made a finding that the entry of all persons from these 6 nations would be detrimental to the United States, that was based on no evidence and no review of any problems or any evidence of any problems that have occurred with the entry of these individuals under the extraordinarily strict conditions that are already present with respect to entry in the United States. It seems, by all accounts, to only be explicable as making good on a promise that he made in the campaign. Not necessarily that he's got Muslim animus, but that he is basically showing his supporters, as politicians often do, that he's making good on a promise to keep Muslims out of America. I don't think that will be in the court's opinion, but I think the court might well fall back on this statutory ground if it reaches the merits. But again, I actually think the most likely result is that it doesn't reach the merits.
Yeah, and just on that point, his own Department of Homeland Security has issued studies, as the Ninth Circuit pointed out, that kind of undermine the national interest conclusion in the executive order.
It does, but I'm fully expecting that whatever comes out of this review will be much more tailored and will be at least premised on what they will say is a much more robust evidentiary predicate. I have no idea what it will be or whether it will be compelling or persuasive, but it won't be the virtual black box that we got in January and March.
Yes, maybe up here in the front, please.
Hi, can I ask two questions? Can you bore down a little bit on Kennedy and the travel ban, sort of what we should look for if it does get to the merits there? And does anyone have any thoughts on evidence that progressive groups or liberal justices have been aggressive getting things before the court or granting cert in certain cases because they may be fearful that the president might get another vacancy sometime in the next couple of years?
Good questions.
So on Justice Kennedy and the entry ban, one starting point is, which I was alluding to, is that he authored a concurring opinion in Kerry versus Dinn a few years ago, which goes to review of consular decisions primarily, and building upon an earlier case, Kleindins versus Mandel. And I mean, there's a certain amount of just criminology involved in reading Justice Kennedy's opinions, but the language in that opinion goes to whether or not, if the baseline rule is that review of substantive immigration decisions is pretty deferential. Kleindins provides for an exception, and the standard is the decision facially legitimate and bona fide. What Justice Kennedy alludes to in that concurring opinion is the notion that if a decision is made in bad faith, then in fact actually that might be an exception to that general rule. So that would be the starting point for thinking about that. He has been one to also he has been in the majority in cases where the court has engaged in the constitutional avoidance to rest on statutory grounds in the immigration context, INS versus St. Cyr being a principle. And he didn't author the opinion, but he joined the majority in that opinion. So that's where I would start. I'm sure others have thoughts as well. Or not.
On the second question, are progressives trying to get to the court now because they think it's going to get worse? Is that the idea? No.
When was the last time organized labor filed a petition in the Supreme Court, right?
I mean, I don't think so. There's a 5-4 loss is just as much a loss as a 6-3 loss.
Interesting. Did anybody else want
And
to weigh
anything
in?
can happen, as we saw last year with Justice Scalia's death, so you never know.
Did anybody else want to weigh in on those? Okay, thank you. In the front?
I have a question for Claire. Specifically, you mentioned the Janus case, and you said you felt more comfort after reading the pleadings or whatever, the filings. Could you elaborate on that?
So the case is still at the cert stage, and I think what I felt is that there are more reasons to deny cert in this case than I knew about before I read the papers. And I think that the jurisdictional issue is a big one. So basically, the case was originally, I think, filed by the governor. He never had standing. Then there were interveners who were going to take the case, and there's some Supreme Court case law about how you can't really remedy the absence of jurisdiction that way. And so, the ask that Right to Work is making in this case is a pretty big ask, right? There's no way what they want is the explicitly the overturning of longstanding precedent. It's not like they're saying, oh, there's a way we can win without that. That's what they want. In fact, they're trying to, there may be ways they could win little things without that they're trying to sort of avoid talking about because they want the big win. And so if you're going to do that, and if you're confident, as this court may be, that this issue is going to come up in another vehicle, because there's tons of these cases out there, then why go with this one?
Claire, you think the court will come to this issue sooner rather than later at some point?
I mean, it's hard to say. All I know is that from tracking all of the cases, that there are plenty of them out there.
Mm-hmm.
I mean, from my own perspective on it, I think this is just a when, not if question. You may well be totally right. I don't know enough about that petition to know if it's a really bad vehicle, and I think it's a very fair point that they're going to want a good vehicle in which to address the issue. But I mean, they took the case and they were clearly ready to reach a result, and I think they will be looking for another opportunity to take it up and reach a result. So.
In the front?
On political gerrymandering, of course, as a matter of constitutional law, race and political affiliation are not the same, but participation in a political party is an association, which is, of course, protected under the First Amendment. So if you have a plan that herds members of a party into a way that dilutes their vote, to me that would seem to sort of surmount the distinction between race and political affiliation that you mentioned. Could you just speak to association and how that might come into the case?
Yeah, I think you've put your finger on one of the theories that has been identified by people to try and come up. I think there's sort of an implicit acknowledgement by the fact that the argument isn't made to try and make it like race, that you have to have a different theory for getting there. And I think, one of those is the idea that, well, the interest here is actually more of a First Amendment and associational interest and less of a pure kind of voting or equal protection interest in the sense of, kind of discrimination. I think part of the problem there is, how do you think about the extent of the burden on association? It's not like people don't have the ability to associate and to to participate in the political process just because they don't get the outcomes they want all the time. And I think one of the really interesting facts that we've seen in history on some of these gerrymandering cases is some of the ones, there's multiple instances where, the lower court was quite confident that there was just this blatantly unfair system that was going to perpetuate forever a bias in favor of one party, and then the very next election after the court issued the decision, it flipped completely, because the reality is that politics is affected by a lot more than just where we're located and where we get to vote, and things change. So I think that you're right, that there's a different interest that's being articulated here, but I think that's part of why this really is just a different animal. If nothing else, it's a different animal, and you can't kind of take the court's existing gerrymandering doctrine and make it work the same way in this context, to the extent it works even in the context where it's been developed, which is, I think people on both sides would debate that a little bit. So, but I think it's one of the difficulties in this case, because you see a lot of attempts by both sides to kind of have pieces of, well, here's where I do think it's like doctrine, and I want to take advantage of existing doctrine, but at the same time saying, well, but it's not quite like existing doctrine, and in some ways this is quite different. And I think that's the struggle that makes it, it's why the court hasn't reached all of this for a long time.
If I could just, I agree with, this is something that I agree with Aaron on, that the contexts are not analogous, right? There are some aspects of the racial gerrymandering cases. I think it particularly when you're trying to assess evidence, right? Because both of these cases, these kinds of cases involve questions about process, motive, what factors were taken into account, and I think the same kinds of evidentiary tests for assessing whether or not race was a factor in the redistricting process are importable into the partisan gerrymandering context. But I entirely agree with Aaron that the theory underlying these cases is very different, right? The racial gerrymandering cases are cases about improper classifications, right? The consequences of those classifications is actually immaterial to the constitutional harm there. The argument is not that one racial group was deprived a certain level of political power or got an outsized level of political power. It's that a consideration that is verboten in our politics, race, predominated, right? And that consideration expresses some racial difference that itself is problematic for politics. That's the theory anyway, and again, like as Aaron alluded to, I think there are people on both sides of the debate on this that would question some of the assumptions of that theory. But here, I agree with Aaron's point that, look, this is a mutable characteristic, right? Your political affiliations are changeable, but I think that's precisely the point underlying the plaintiff's legal theory here, right? That people's preferences in terms of candidates and political parties may shift. They have a right to associate with those candidates, and that right entails, I think, a notion not just that you sort of cast a ballot and express your views, but that your views manifest themselves in some way in the distribution of political power in a meaningful sense, right? And if you draw lines in a way that negates those shifting preferences, then that unconstitutionally burdens your associational preferences at a certain level. I mean, if you think about if the redistricting process went this way, people voted for their preferred candidates or their preferred parties. And then after all the ballots were cast, the government came in and then drew the lines to decide which votes were in which districts in order to achieve a predetermined outcome of locking one particular political party into power. No one would think that that's permissible, right? And I think the question is here whether or not if a political party tries to do that before the election and actually effectively achieves that result, right? Whether or not that's meaningfully different, and we think not.
But this is why your question, this is very hard to explain to students and to the public for the following reasons. It may not be immutable, but yes, you're right. Of course, in virtually every other area of constitutional law, and this one, I think Justice Kennedy has said, if the state came out and said, the legislature said, we are drawing these lines in order to entrench the Democratic Party control over these seats, that would be an illegitimate motive. That's, the government's not supposed to be structuring the way it works in order to entrench one party's power. That's never supposed to be okay. But where Aaron's absolutely correct is, that was Justice Stevens' idea. If it's very obvious that the legislature is trying to entrench one party's control over seats or districts rather than another's, that's simply an illegitimate basis under equal protection law for doing something. Justice Kennedy just didn't buy that as a theory that he was willing to accept in both Veith and the Lulock case that followed Veith. And that's why everyone is now obsessed not with motives or with an intent test, but with effects tests of the sort that Derek was talking about. There is something weird about that, because we naturally think that why is the Wisconsin legislature trying to secure power for the Republican Party? Why is that a legitimate state interest at all? But Justice Kennedy has said pretty clearly he's not willing to make that the basis of the doctrine.
I think we may have time for one more question. In the middle, please.
Thought we might have heard a little bit more by now about Neil Gorsuch. So in a few remaining minutes, would love to hear thoughts on what to expect from our newest justice.
Thank you.
He's very timid. I think he demonstrated, he issued 7 separate opinions in the course of 4 days at the end of last term, which I think it took the last justice, Justice Kagan, took her something like 3.5 years to do likewise. He is not shy about expressing his views. I'm not sure why or how that will be received by his colleagues, but he seems to want to, in a way, something like Justice Thomas, but with a different valence, I think, wants to set out his views, whatever they might be, and regardless of where the rest of the court is and regardless of where the doctrine is, in each case. He sees himself as being something of an iconoclast and something, this is just based on his 1 month in office, right? That could change radically. Justice Stevens was actually, in his early years on the court, issued separate opinions all the time. It seemed like he refused to join any opinion that he didn't agree 100% with. And over time, that definitely changed. And so perhaps Justice Gorsuch will likewise become more of a team player than he demonstrated in April of 2017.
I do think one of the really interesting cases to watch him on will be the Carpenter case, just because that's an area, Fourth Amendment and criminal law in general, is one of the areas where you just get disagreement even among justices who are otherwise like-minded or otherwise, inclined toward the same outcomes about reasoning. And I think that'll be a really interesting case to just get more of a sense of his approach to constitutional analysis, his approach to criminal issues in particular. I think it'll tell us some things that will be applicable beyond the context of that particular case.
Thank you. And
can I add just one
please,
thing?
yes.
I mean, this is. I think I'm the only panelist from outside the Beltway, so this may be just an outside the Beltway observation. It's not a substantive point, though. I mean, it's not. I mean, it's just descriptively the case that Neil Gorsuch's nomination was a very polarizing nomination for all the obvious reasons. And when I talk to people, there are people who fully accept his nomination as normal and legitimate. But there were a lot of people in the country who paid attention to that process more than they might to some other more anodyne Supreme Court nomination process, for whom there's a cloud over his head. And one of the things that I was struck by is that what Marty is alluding to, I wondered the extent to which that actually serves his long-term interests in sort of alleviating that cloud. Letting that cloud move off. And it sort of contrasts in some ways to the way Chief Justice Roberts has thought about his role as Chief Justice in institutional terms. And I wonder if that's a tension that might may emerge or not emerge. It's just something that, what Marty is alluding to is sort of something that struck me in those terms.
And we'll see, maybe next year at this time we'll have more to say on this. I do want to thank you for the question. It's interesting that we had an hour-and-a-half discussion about this, and if somebody can fact-check me, but I don't think we mentioned the word Gorsuch once until your final question, so thank you very much. And I want to thank you all for coming again today and participating, and thank you to the panelists.